never said that he remembered anything from that March 25th phone conversation with the Clinton people. Of course, that was days before he bleach-bitted the emails. He never said he had any factual knowledge of anything that happened on that call. Is that his basic statement? So I read the 302s. He didn't really provide any information.
I can't remember for sure being the 302. You've probably seen it more recently.
Well, I saw one 302 said that he pled the Fifth. Obviously, he was given immunity. Another said that there was an invocation of attorney-client privilege at one time in one of the other summaries. So I'm just trying to figure out, what happened with Gambetta. Why was he not able to provide information? He had immunity. This was something that was much more fresh in his mind than previous conversations with Clinton people would have been. And yet you said he was credible. To me, feigning ignorance, that is not credible given the timeline where you have the New York Times saying that this server existed. The House immediately sends a subpoena. He has this conversation, and then lo and behold, a few days later, all the emails are bleach-bitted.
Oh, he told us that with immunity, that no one directed him to do it, instructed him to do it. We developed no evidence to contradict that. Again, we're never in the business of believing people. The question is always, what evidence do we have that establishes disbelief? We don't have any contrary evidence. His account is uncontradicted by hard facts.
Well, he's in a situation where these things are now under a subpoena, and he has conversations with people who they potentially could implicate, and then he takes this action. So I guess the question is it more reasonable to think that he just would have said, oh, you know what, I just need to all of a sudden bleach-bit this stuff without any direction at all? I just find that to be something that is difficult to square. Let me ask you this. In September, you sent a memo to your employees at the FBI basically defending the way the Bureau handled this investigation. Why did you send that?
It was about how we were doing transparency, because there was all kinds of business about whether we were trying to hide stuff by putting it out on a Friday, and I wanted to equip our workforce with transparency about how we were doing our productions to Congress so they can answer questions from their family and friends. I want them to know we're conducting ourselves the way they would want us to.
And because you mentioned former agents and people in the community, I mean, this has provoked some controversy within the ranks of current and former agents?
Not within the FBI. Again, who knows what people don't tell the director, but I should have asked Mr. Gohmert. If there are agents of the FBI who are concerned or confused about this, please contact me. We'll get you the transparency you need to see that your brothers and sisters did this the way you would want them to.
All right, I'm out of time, but I will say just when I was in the military, you had said no one would be prosecuted. I mean, maybe that was just for civilian, but I can tell you that people, if you had compromised top secret information, there would have been a court-martial in your future, and I yield back.
Would the director care to respond to that?
No, fine.
It's a direct comparison to the finding of yourself that, as you stated in your news conference, that no prosecutor would prosecute somebody under similar circumstances.
I understood Mr. DeSantis to be expressing a personal opinion. I accept that at face value. I just haven't seen the cases that show me on the public record that that's true. But I accept his good faith.
The chair recognizes the gentleman from Texas, Mr. Ratcliffe, for 5 minutes.
Thank you, Mr. Chairman. Director, did you make the decision not to recommend criminal charges relating to classified information before or after Hillary Clinton was interviewed by the FBI on July the 2nd?
After.
Okay, then I'm going to need your help in trying to understand how that's possible. I think there's a lot of prosecutors or former prosecutors that are shaking our heads in how that could be the case, because if there was ever any real possibility that Hillary Clinton might be charged for something that she admitted to on July the 2nd, why would two of the central witnesses in a potential prosecution against her be allowed to sit in the same room to hear the testimony? Now, I've heard your earlier answers today. You said that, well, it was because the interview was voluntary and they were her lawyers. But I think you're skirting the real issue there, Director. First of all, the fact that it was voluntary, it didn't have to be, right? You could have impaneled an investigative grand jury. She could have been subpoenaed. And I know you've said that you can't comment on that, and I don't really care about the decision about whether or not there should have been a grand jury here. But since you didn't have one, it goes to the issue at hand about whether or not this interview should have ever taken place. With due respect to the answers that you've given, the FBI and the Department of Justice absolutely control whether or not an interview is going to take place with other witnesses in the room, because the simple truth is, if, under the circumstances as you've described, those interviews never take place. If there was ever any possibility that something Hillary Clinton might have said on July 2nd could have possibly resulted in criminal charges that might possibly resulted in a trial against her relating to this classified information, well, then to use your words, Director, I don't think that there's any reasonable prosecutor out there who would have allowed two immunized witnesses central to the prosecution to proving the case against her to sit in the room with the interview, the FBI interview of the subject of that investigation. And if I heard you earlier today, in your long career, I heard you say that you've never had that circumstance. Did I hear you correctly?
That's correct. But
okay, and I never have either, and I've never met a prosecutor that's ever had that. So, to me, the only way that an interview takes place with the two central witnesses and the subject of the investigation is if the decision has already been made that all three people in that room are not going to be charged.
Okay, can I respond?
Yes, please.
I know in our political life sometimes people casually accuse each other of being dishonest, but if colleagues of ours believe I am lying about when I made this decision, please urge them to contact me privately so we can have a conversation about this. All I can do is tell you again, the decision was made after that because I didn't know what was going to happen in that interview. She maybe lied during the interview in a way we could prove. Let me finish. I would also urge you to tell me what tools we have as prosecutors and investigators to kick out of an interview someone that the subject says is their lawyer.
That's not my point. The interview never should have taken place if you were going to allow the central witnesses that you needed to prove the case to sit there and listen to the testimony that the subject was going to give. It never happens. It never happened to you, and it's never happened to me or any other prosecutor that I've met. And I know you've defended the people that were involved in this as being great, but if it's never happened, I wonder why this is a case of first precedent with respect to that practice that you and I have never seen in our careers.
You and I don't control the universe of what's happened. I suspect it's very unusual. A key fact, though, that maybe is leading to some confusion here is we had already concluded we didn't have a prosecutable case against Heather Samuelson or Cheryl Mills at that point. If they were targets of our investigation, maybe we would have canceled the interview. But frankly, our focus was on the subject. The subject at that point was Hillary Clinton.
All right, let me move on. According to the FBI's own documents, Paul Gambetta was, in his first interview on February the 18th, told FBI agents that he had no knowledge about the preservation order for the Clinton emails. Correct?
I don't know the dates of that, but I'm sure it's in the 302.
Okay, but then 2.5 months later, on May the 3rd, his second interview, he made a 180-degree turn. And he admitted that, in fact, he was aware of the preservation order, and he was aware of the fact that that meant that he shouldn't disturb the Clinton emails. Correct?
Yep.
Okay, well then I need your help again here, because when I was at the Department of Justice, your reward for lying to federal agents was an 18 U.S.C. 1001 charge or potential obstruction of justice charge. It wasn't immunity.
Depends on where you're trying to go with the investigation. If it's a low-level guy and you're trying to move up in the chain, you might think about it differently.
Well, he lied to an FBI agent. You don't think that's important?
Oh, it's very important. Happens all the time. Unfortunately, it's very, very important. Sometimes you prosecute that person and end their cooperation. Sometimes you try and sign them up.
But if they lie to an FBI agent after they're given immunity, they violated the terms of their immunity agreement.
Oh, sure, after the agreement.
And so that's my point. He shouldn't have immunity anymore.
Oh, I'm sorry, I may have misunderstood you. He lied to us before he came clean under the immunity agreement and admitted that he had deleted the emails.
No, not according to the FBI's documents. He had the immunity agreement in December of 2015. These interviews took place in February and March and May of this year, 2016.
Gambetta?
Gambetta.
Okay, then I'm confused and misremembering, but I don't think that's right.
Okay, well, my time's expired, but I have one last question, and I think that's important. At this point, based on everything, do you think that any laws were broken by Hillary Clinton or her lawyers?
Do I think that any laws were broken?
Yeah.
I don't think there's evidence to establish that.
Okay. Well, I think you're making my point when you say there's no evidence to establish that. Maybe not in the way she handled classified information, but with respect to obstruction of justice. And you've got a pen here. I just want to make sure the record's clear about the evidence that you didn't have, that you can't use to prove. So this comes from the FBI's own report. It says that the FBI didn't have the Clintons' personal Apple server used for Hillary Clinton work emails. That was never located, so the FBI could never examine it. An Apple MacBook laptop and thumb drive that contained Hillary Clinton's email archives was lost, so the FBI never examined that. 2 BlackBerry devices, provided the FBI didn't have SIM cards or SD data cards. 13 Hillary Clinton personal mobile devices were lost, discarded, or destroyed with a hammer, so the FBI clearly didn't examine those. Various server backups were deleted over time, so the FBI didn't examine that. After the State Department